The closing process is the final and most critical stage in a real estate transaction. It involves the legal and financial steps that ensure the proper transfer of ownership, finalization of the loan, and disbursement of funds. A well-informed real estate licensee plays a key role in educating clients, coordinating professionals, and ensuring contract timelines are met. What is closing in a real estate transaction? Closing refers to the culmination of the real estate purchase, where legal ownership is transferred from the seller to the buyer, funds are disbursed, and the deed is recorded with the county. Typical closing timeline. From contract acceptance to recordation, usually 30 to 45 days, depending on the loan type and buyer preparation. Process overview. 1. Contract acceptance. 2. Escrow opens. 3. Inspections and due diligence. 4. Loan processing and approval. 5. Appraisal and title clearance. 6. Final closing disclosure and signing. 7. Loan funding. 8. Title transfer and recordation. 9. Buyer receives keys. Statutory note AAC R4 28 1101B requires licensees to clearly communicate each step of this process to ensure the client understands obligations, timelines, and expectations. Step-by-step breakdown of closing. Step 1. Escrow opens. Buyer's earnest money is deposited with the title escrow company, which holds funds as a neutral third party. Escrow officially begins upon mutual acceptance of the contract. Step 2. Title search and preliminary title report. Title company searches public records for liens, encumbrances, or clouds on title. Preliminary title report is issued and reviewed. Step 3. Loan processing and underwriting. Lender verifies O buyer's income and employment O credit report and scores O asset documentation, bank statements, retirement funds. Step 4. Appraisal and property inspections. Lender orders an appraisal to verify property value. Buyer conducts home inspections during the inspection period. Step 5. Conditional loan approval. The underwriter issues conditional approval pending satisfaction of specific documentation or appraisal results. Step 6. Closing disclosure, CD. Must be delivered to buyer at least 3 business days before signing. Details. O loan terms, O monthly payments, O total cash to close. O closing costs. Regulatory reminder. ARS Paragraph 6-834 and TRID regulations require that the closing disclosure be accurate and timely. While this is a lender's duty, agents must track the timeline and ensure the CD is received on time. Step 7. Final document signing. Buyer and seller sign their respective documents. O deed, O promissory note, O closing instructions, O final affidavits, or disclosures. Step 8. Funding and disbursement. After signatures and final lender review, funds are released to escrow. Escrow pays off seller's mortgage, prorated taxes, commissions, and other costs. Step 9. Recordation and delivery of keys. The deed is recorded with the county recorder's office. Ownership is officially transferred. Buyer receives keys and access to the property. Roles and responsibilities in closing party responsibilities. Escrow officer manages documents, receives, disburses funds, coordinates recording. Lender funds loan, ensures underwriting and regulatory compliance. Buyer and agent submit documents, perform inspections, respond to contingencies. Seller and agent disclose known issues, complete repairs, vacate by close of escrow. Title company ensures clean title, issues title insurance, handles recordation. Commissioner reminder, AAC, R4 28 1101A, obligates licensees to protect their clients' interests by coordinating with all parties and ensuring no delays in the transaction timeline. Client concerns and expectations. Real estate agents must anticipate and address common buyer-seller concerns. 1. Delays in approval or funding. Lenders may delay due to incomplete documents or verification backlogs. Appraisals or HOA documents can also delay closing. Agent's role: follow up with lenders and escrow proactively to avoid surprises. 2. Unexpected closing costs. Buyers may be surprised by prepaid items, owe property taxes, owe homeowners insurance, owe loan origination fees, owe title and escrow fees. Example: a buyer may budget $10,000 for closing, but receive a closing disclosure showing $12,500 due to prorated taxes and impound accounts. 3. Signing confusion. Clients may not understand loan terms or settlement documents. Remote notary or mail-away closings may cause delays if not planned early. Agent tip: review the CD with the client in advance and help them confirm required identification or documents for signing. 4. Communication breakdowns. When the buyer, lender, escrow, and agents aren't aligned, confusion arises. Best practice: use shared email updates or transaction management tools, like Skyslope or Dotloop, to keep everyone on the same page. Legal and ethical compliance. AAC R4281101 B. Agents must clearly communicate and disclose all material information, including delays or required documentation. ARS Paragraph 6.834 establishes CD timing rules under TRED. Agents must understand the 3-day delivery rule and assist buyers in meeting it. Arizona Department of Financial Institutions regulates mortgage lenders and brokers, ensures ethical and accurate closing practices. AAC R4281101I requires that licensees communicate all material facts, including escrow holdups or title issues. Understanding the full closing process prepares real estate professionals to confidently guide clients, reduce surprises, and prevent deal failure. From opening escrow to recording the deed, agents must anticipate potential issues, coordinate with all professionals involved, and ensure clear communication throughout the transaction. Always remember, the agent's role doesn't end at contract, it intensifies during closing. Proactive support, ethical behavior, and statutory compliance are essential to delivering a smooth transaction experience.